Now, what then happens when a defendant informs the court that he has nothing more to say? Nothing at all to say. What happens? The answer is this. One, the court will tell the person to file his written address. This is what the judge did in his case yesterday. Two, when the address is filed, Nnamdi will be expected to serve a copy of it on the prosecution. The written address should be a summary of the arguments, stroke points of law, and decided authorities in support of Nnamdi Kanu's case. Okay? Now, three, when he serves his address on the prosecution is expected to also file its final address and serve it on Nnamdi Kanu. Nnamdi will then be expected to file a reply address and serve it on the prosecution. So Nnamdi is going to file two addresses, while the prosecution is going to file one address. Three addresses are usually filed. Nnamdi will file the first one, the prosecution will reply, and after that, Nnamdi will file the second and the last address in the matter, right? That will mark the end of the proceedings in the matter. Once the three addresses are filed, it will mark the end of the proceedings in the matter. A date will then be fixed for judgment, right? A date will then be fixed for judgment. Now, there are some concerns at this point about this matter, the way the matter is going. There are some concerns, and this is pure issue of law, right? I hope you understand it that way. Number one, legal submissions are tailored submissions. You are not allowed to say everything you would have loved to or everything that happened. You just tailor it to the facts in issue. You tailor it to what the prosecution has presented against you in the court. The prosecution has said this and that, so you just go straight to those points and show the court why the prosecution's case should not be accepted. And then you have decided authorities to support your position. It is tailored. It is measured. Okay? They are guided submissions and must be supported by law and decided cases. This can better be done by legal experts. And that maybe explains why the judge, who is himself an expert in law, told him to seek the advice of legal experts. Right? Now, if you are not trained in law, I tell you, it might be very difficult, if not impossible, to make the legal submissions needed to defend anyone in court. It's like in medicine. If you're not trained in medicine, it might be difficult for you to carry out an operation. What the defense lawyer does in court is similar to an operation. And for you to successfully carry out an operation in medicine, you must be a trained medical expert. So, one major concern in this matter is the fact that Nnamdi is not a lawyer. And so, having chosen to do all of this by himself, it is a bit concerning. But at the same time, the law allows him to do it by himself. And if Nnamdi believes that he can do it successfully on his own without the services of his lawyer, that's fine. He goes ahead to write the final written address, cite the written authorities, and then submit it to the court. The court will take, the court will read. But note that this is a hurdle on its own. The writing of final written address, it's a hurdle on its own in the field of law. Number two, this is another concerning issue. The challenge in this case is that this very court dismissed the no-case submission that was made by Kanu Agabi, senior advocate of Nigeria, and other senior advocates for Nnamdi. After the case of the prosecution, the senior lawyers made a no-case submission and said, my lord, from everything that the prosecution has presented to the court, there is no case for Nnamdi to answer. There's no prima facie case that has been established against Nnamdi Kanu, so allow him to go. But the judge, in his ruling, dismissed the no-case submission. And what did he say? He said that something has been said against Nnamdi that requires Nnamdi to enter his defense and then defend himself. Now, that ruling has not been set aside. That ruling has not been appealed. That ruling is still there. So, how does Nnamdi you know, avoid that ruling? How does he jump that ruling that said that he has a case to answer, no matter how little? How does he jump that ruling that said, let us hear from you? Talk to the court, let us hear from you. That is a hurdle. The ruling on the no case submission becomes something to worry about because that ruling is still there. This is why I feel a lawyer or lawyers should have assisted Nnamdi to get over this. Now, but like I said, Nnamdi has chosen to defend himself and it is within his rights. If he believes very well that he can, he can pass through all that hurdle in the final written address alone, that's beautiful. The court is still going to look at it. The next question is, if Nnamdi refuses to submit a written address, can the judge still proceed into the matter? The answer is yes. As a matter of law, the final written address is just something to assist the courts, streamline the arguments, raise the issues that are considered germane, and then make the legal arguments and support authority for the courts to guide the courts. But in the absence of final written address, the judge resorts to the evidence that was presented to the court and can use that to decide a case. So if Nnamdi says on the next adjourned date, my lord, I am not filing a final written address. I told you there's no case against me. Decide this matter anyhow you want to decide it. The judge can go ahead and decide the matter based on the evidence and not necessarily, based on the final written address. But that does not stop the prosecution from filing its own final written address. If Nnamdi refuses to file final written address, the prosecution's right to file final written address does not cease. The prosecution can file its own, right? The next question is, when the final written address is adopted, how long will it take the court to deliver judgment? The answer is within 90 days, right? Within 90 days. So that means from the day of adoption, judgment must, as a matter of law and constitution, be delivered within 90 days. That means within 3 months. It must be delivered. The judge cannot hold this judgment beyond 3 months. One day after 3 months, that's 91 days, that judge can be queried by the Nigerian Judicial Council, National Judicial Council. So every judge avoids that and makes sure that when final written addresses are adopted, judgment is given within the time frame of the Constitution, and the Constitution of Nigeria says within 90 days. So once it is adopted, in 90 days, Nnamdi knows his fate because judgment must necessarily, and as a matter of law, be delivered. This is Nnamdi Kanu himself. And we wait to see how the events unfold in this matter. We wait to see how it unfolds. How Nnamdi presents his case on the next adjourned date. The final written address gets it adopted. The prosecution also gets its own adopted. And then we get to see the verdict of the court in this matter.